Welcome back. Let's talk about the Electoral Act. It's still been amended somehow because the other day they were amending a provision that has to do with dual membership of political parties. That's around Section 77. And there has been called to relook again or look again at that Electoral Act to amend a few things prior to the next general election. Now, Senior Advocate of Nigeria, Jibrin Okutekpa, had raised concern about the grounds for petition in the new Electoral Act, which he says perhaps is in contravention of the Constitution, and also it's like creating a leeway for all kinds of elements to get all kinds of paperwork to run for office. Let's bring in my guest, Mr. Kemini Udim. He's a legal practitioner. Mr. Udim, thank you so much for coming on the program. Mr. Kemini, can you hear us? Oh dear. So let's see how much as soon we can establish connection with Mr.
Yes, I can.
Oh, fantastic. Can you hear me now? Mr. Odim, can you hear me? All right. So while we try to establish connection, guys, so if you look at Section 66 of the Constitution, now this section has there's one for governors, there's one for president and all of that, but Section 66 that has to do with, for instance, the Senate. It said Section 66(1), I think 1I, as captured in the 1999 Constitution as amended, says, let me read from the very, no person shall be qualified for election for the Senate, to the Senate or the House of Representatives. This also applies to other offices like governors and the president. If he has presented a forged certificate to the Independent National Electoral Commission. So it's a ground norm. Our ground norm says that if your certificate is not original, it wasn't given to you from an institution, of course, it's a ground for you not to be qualified for election. That can, even if you win the election, you could lose that election or that's it. Now, when we go to Section 134 of the Electoral Act 2022, you'll see that an election may be questioned. This is the grounds of petition where people protest or disagree with the results can take to court. An election may be questioned on any of the following grounds. Subsection 3 of 134 of the old Electoral Act says, with respect to subsection 1, a person is deemed to be qualified for an elective office and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, it meets the application requirement of Section 65, 106, 131, 177 of the Constitution, and is not, as may be applicable, in breach of Section 66, 107, 137, 182 of the Constitution that I just read, part of which is what I just read. But in the new law that has been amended, the repeal and reenactment, Section 138, that has to do with grounds for petition, there are only three major provisions there. An election may be questioned on the grounds that, 1, election was invalid by reason of corrupt practices or non-compliance with the provisions of this act, or respondent was not duly elected by majority of lawful vote cast at the election. And that was just it. Besides all of that subsections that was listed. Mr. Kemini, can you hear us now?
Yes, I can hear you.
So the senior advocate, the learned sake, has raised concern that what is going on with the expunging of what was in subsection 134, subsection 3, that aligned with Section 66, for instance, and other sections, 107 and more, of the Constitution that has to do with if you present a forged certificate, that's a ground for you not to be qualified to be elected, or if you're caught in between, you're out. So do you think that with the framing of Section 138, this is silent about forgery of certificate, or there's something we're missing out here?
It's silent about forgery of certificates. You see, all along we've been 4 grounds for one to challenge an election. And in the 2022 Electoral Act, which was signed into law by immediate past president of the country, President Muhammadu Buhari, God rest his soul, we now have 3 grounds to challenge election, okay? And those are the 3 grounds that you read in Section 134, sub 1 of the 2022 Electoral Act. We still had in that ground that you can challenge an election if a person whose election that you are taking to the court at the time of the election was not qualified to contest the election. And I have done election petition matters. I've used this section, okay, against the person that won election. I've also used this section to defend. So some of us are very surprised that this section has been removed, this ground has been removed from for the questioning of an election for a very strange reason. Some of the persons that stand election in this country, most of them, very unfortunately, go shopping for certificates that are very questionable. When the institutions that the names of the institutions are written on those certificates, when you go searching, when you go verifying, you see that someone has presented a certificate that is not in existence whatsoever. And don't forget what happened in 1999 when the first speaker of the representatives, you remember the Toronto matter, right? So it shows clearly that we've been having situations in this country where people present forged certificates. And now you have removed the that very ground from the grounds for the questioning of an election. So it simply means that you cannot go to the election petition tribunal from the 2027 election, after the 2027 election. You cannot proceed to the tribunal to challenge anyone who has a forged certificate, who presented a forged certificate to INEC. If you go, it will not be taken as a ground for election petition. It will be struck out. Maybe you will now have to go to the civil court, to the regular court, and then seek to prosecute the person for forgery of certificate. But as a ground to lead to the disqualification of the person, as a ground to lead to taking that victory from him and giving it to another person, certainly it is no more going to be the case as we move into the 2027 election. The tribunal is not going to attend this. I mean, attend this as a ground. And some of us are very surprised about this. What could be the rationale? Because everything that we need to do to rid the country of elements that go into the forgery of certificates to gain undue advantage over the other, especially those that are seeking public office. I thought that as a country, we should encourage such. And the removal of that grounds from the 2026 Electoral Act that has been signed by the president into law is, for me, very surprising.
Mr. Odim, let me pick up on your surprise and tie it to the consultation level ahead of the passing of the Electoral Act Amendment, Repeal and Reenactment 2026. Of course, there were hearings, there were engagements with civil society, with what's the name of this body, PLAC. There were a number of awareness, drives ahead of the final document. And so how did they miss out on this particular critical portion of the document? Would you ascribe it to the concentration, the attention on Section 63 sub 3, which is the very critical component of the demand for electronic transmission of results?
Well, I think so, because at some point Nigerians were very much interested in the issue of transmission of election results from the polling units to the collation center electronically. Many citizens were more interested in that, and I think to that extent, other provisions of the Electoral Act, which were equally very fundamental, were ignored. But I also take this to the lawyers in the National Assembly. The National Assembly is made up of so many lawyers, some very senior lawyers, some very experienced legislators that have been in Parliament for many years. Most of them have also gone to election petitions because there is basically no season that the election petition tribunals are empty. So lots of persons are taken to the election petition tribunals, and they are there in the legislature to be the National Assembly, the senior lawyers and all of that. I would have expected that they themselves should be able to point this out and say, look, gentlemen, we need to bring this in. We need to return this in the Electoral Act. Like I say, at this point in our national history, every effort, every attempt to discourage people from forging certificates and using it to gain undue advantage and become legislators, become public, officers over and above others that have genuine certificates. I thought that such efforts should be encouraged rather than discouraged by the removal here. And when you talk about public hearing, how many public hearings do we really, have in this country when it comes to critical laws like this? The gentlemen, they will go, make their observations. Do we have these observations accepted by the legislature, by the National Assembly? Do we have them factor these suggestions into the pieces of legislation that are about to be passed? It looks to me like the public hearing is just formality. You go, you speak to Runchi. After that, the legislature still goes ahead to do exactly what they wanted to do. And I'm saying that the removal of that very ground that talks about the person not being qualified, is for me a minus. It's for me something that is not really good. Yes, the Constitution has given the parameters, the qualification for one to be elected to any public office. At the same time, the Electoral Act, over the years have also been there to supplement, have also been there to make very clear provisions, elaborate provisions, to be able to guide the conduct of the election. I would have expected that that ground would still be there. I do not know the reason, and the reason cannot be so persuasive enough to lots of citizens of this country as to why that very provision was removed. If the Electoral Act were to be amended again today, I would have requested that that very provision should be retained in the Electoral Act.
Well, it's always said that any law would be some sort of mixed bag. You have the progress, you have the gaps, you have the drawbacks as well. And I wonder for you, when you look at this law as a whole, what percentage would you give to progress that has been made with this law? What percentage would you give to gaps that may have been created? And what percentage would you give to obvious drawbacks?
Well, talking about percentage, I still have to commend the National Assembly for the new Electoral Act. It's not total failure. There are some provisions that are good. For instance, the provision that allows me to print my voter's card from wherever I am without necessarily having to go to where I registered to be able to get the voter's card. That provision allows me to go to the internet, print it out, and then make use of it for election. And I think that's a progressive kind of provision. There are also some sections of the Electoral Act that has provided stiffer punishments for those that adulterate the electoral process. And I think that is good enough. And talking about other provisions, for instance, the one that says that if you're a public officer, if you're maybe a commissioner in a state or a minister or a personal assistant, and you want to contest election, you resign ahead of the primaries. I think that that provision is in contradiction with the Constitution, because the Constitution talks about resigning 30 days before election. This one says you resign before primaries. It doesn't specify the number of days. So that means you can resign a day before the primaries or 2 days before the primaries. And I was thinking that when making laws, the legislators should be looking at the new law side by side with the provisions of the Constitution to ensure that there is no conflict, because in law, when there is a conflict between a subsidiary legislation, okay, in this case, an act of the National Assembly, which is subsidiary to the Constitution, the provisions of the Constitution would take precedence, and these other ones will become null and void. So if someone challenges, that provision that says you resign before the primaries, I'm sure that that person will have a reasonable course of action before the court, the Federal High Court in this case, for that trial. So the Electoral Act is signed into law by the president. Yet Nigerian citizens have said that the president was so much in a hurry to sign it into law. The president has come up to defend it, to say yes, he had to sign it immediately. That's fine. We do not want laws to be kept in the cooler for too long after they have been passed. So we encourage that speedy signing. But at the same time, I remember that in the last administration, one thing that stood out for President Muhammadu Buhari was the fact that after a law had been passed by the National Assembly and sent to him, he gave it some time. I'm sure he sent it to a team of experts working with him, legal experts, professors of law, senior advocates, and other, seasoned legal practitioners to be able to go through and then see what is in conflict with the Constitution. And you remember that the former president of Nigeria had, on several occasions, sent back a law to the National Assembly for correction of things that would certainly be difficult to implement, and the National Assembly corrected and then sent back, and then we had something very good for the entire country. I would have expected the president to also have that in his team, so that laws are not correctly signed, and so soon thereafter we're asking for amendments so as to make it practicable, so as to make it easy for implementation. So I think moving forward, the president, yes, we want laws to be signed quickly, okay, but at the same time, there is need for some scrutiny to be able to see whether we're going to be able to implement some provisions of a law, or it is going to create difficulty, in the court when it comes to the issue of implementation.
Yeah, Kevin, we'll continue to touch base with you. Just one-liner answer. The question is, what happens when an act of parliament is in contravention with the ground norm? Because I've seen some provisions in the Electoral Act that are clearly in contravention with the ground norm. What happens at the petition level?
When you look at the provision of the Constitution, Section 1, which talks about supremacy of the Constitution, it is clear that any law that is in contravention of the provisions of the Constitution is, to the extent of its inconsistency, null and void. And therefore, all what anybody needs is to challenge it. Even at the tribunal, you can challenge it there and ask the tribunal to strike it down, to strike out that section that is in contravention to the Constitution. Or even before going to the tribunal, anybody can go to the Federal High Court and then seek the Federal High Court to interpret and strike down a provision of the Electoral Act that is in contravention with the provisions of the Constitution of the country.
Interesting days ahead, a lot to look at. I think a lot of Nigerians and everyone literally was lost in Clause 60, subsection 3, which is now a provision as a section, that there's so many things. I don't even know whether some of these lawmakers are aware of what is even in this provision, whether some people snuck it in, and we don't know. We'll get to find out eventually. But I want to thank you, Kemidim. He's a legal practitioner joining us virtually. Thank you, sir.
Thank you for having me.
We'll take a break, and when we come back, we'll bring in Professor Anthony Killer, who is going to bring us up to speed as his perspective on what's playing out in the political space broadly as we discuss the state of the nation. Stay with us.